CPL 410.90. The court may at any time terminate either a period of probation other than lifetime probation for conviction to a crime or a period of conditional discharge for an offense. 2. The court may terminate probation for a person subject to lifetime probation and who has been on unrevoked probation for at least 5 consecutive years. The court shall grant the request for termination when, having regard to conduct and condition of probationer, the court is of the opinion that 1. Person no longer in need of guidance, training, or assistance that would otherwise be administered through probation supervision. 2. Probationer has diligently complied with terms and condition of sentence. And 3. Termination of sentence of probation is not adverse to the protection of public. No such termination shall be granted unless court is satisfied that person who is otherwise financially able to comply with an order of restitution or reparation has made a good faith effort to comply therewith. The court shall grant a request for termination of sentence of CD when, having regard to condition and conduct of defendant, court is of opinion that 1. Defendant has diligently complied, and 2. Termination of sentence of CD is not adverse to protection of public. (410.90-A), effective October 1st, 2018. Notwithstanding any provisions of this article, all proceedings relating to JO or AO shall be heard in youth part having jurisdiction, and any intrastate transfers under this article shall be between courts designated as a youth part. 420.10. Civil proceeding for collection. A fine, restitution, or reparation imposed or directed by court shall be imposed or directed by written order of court containing amount thereof to be paid. The order shall direct DA to file a certified copy of the order with county clerk in which the court is situate, except where the court issues such order is the Supreme Court, in which case the order itself shall be filed by the clerk of the court acting in his or her capacity as county clerk. Such order shall be entered by county clerk in the same manner as a judgment in a civil action pursuant to 5016 CPLR. Even if defendant was imprisoned for failure to pay the fine, restitution, or reparation, or has served imprisonment imposed, such order thereafter may be collected in the same manner as a judgment by the victim, or to whom restitution was ordered to be paid, the estate of such person, or the DA. So, when there's a civil judgment for a failure to pay restitution or the fine, the DA or the person who was supposed to get paid can enforce the judgment. The entered order shall be deemed to constitute a judgment roll as defined in 5017 CPLR, and immediately after entry of such order, the county clerk shall docket the entered order as a money judgment, which means it starts collecting interest from the date of such docketing. Wherever appropriate, DA shall file a transcript of the docket of the judgment with the clerk of the county of the state. The clerk of any other county of the state. Such a restitution or reparation order, when the docketed, shall be a first lien upon all real property in which defendant thereafter acquires an interest, having preference over any other liens, security interests, and encumbrances whatsoever, except 1. A lien or interest running to the government of the U.S. or the state of New York or any public subdivision or public benefit corporation thereof, or 2. A purchase money interest in any property. B. The DA may, in his or her discretion, and must, upon court's order, institute proceedings to collect the fine, restitution, or reparation. 7. Undisbursed restitution payments. The official organization remitting the payments may place them in an interest-bearing account. The interest accrued in any undisbursed payment shall be designated for the payment of restitution orders that have remained unsatisfied for the longest period of time. For the purpose of this section, the term undisbursed restitution payments shall mean payments who have not been disbursed to the intended beneficiary and such payment has gone unclaimed for a period of 1 year and the intended beneficiary cannot be ascertained by the official or organization after using reasonable efforts. Sub A. The chief elected official in each county and in New York City the mayor shall designate an official or organization other than the DA to be responsible for collection of restitution and reparation. This official or organization shall be eligible for the designated surcharge provided for by Sub 8 of 60.27 Penal Law. B. The agency shall be responsible for collection of data on a monthly basis regarding the number of orders issued, the number of satisfied orders, and the information concerning the type of crimes that they were ordered. 4. A probation department designated as restitution agency shall then forward the information to the Office of Probation and Correctional Alternatives within the first 10 days following the end of each month. In all other cases, the restitution agency shall report to the division directly. The division shall compile and review all such information and make recommendations to promote the use of restitution and encourage its enforcement. 42010 sub 4. Period of imprisonment. When the court directs the defendant be imprisoned until the fine, restitution, or reparation be satisfied, it must specify a maximum period of imprisonment subject to following limits. A. For a felony, 1 year. For a misdemeanor, not exceed 1/3 of the maximum authorized term. For petty offense, not more than 15 days. When the person fails to pay a fine, restitution, or reparation, such provision may be added at the time sentence is pronounced or at any later date, while the fine, restitution, or reparation, or any part thereof remains unpaid, provided, however, that the defendant must be personally present when such provision is added. This is talking about a jail provision. Okay, then it goes on to a thing about when the guy gets arrested for a warrant, he's brought before an alternate local criminal court or the superior court and the court's not available, the officer may bring the defendant to a local correctional facility of the county in which the court sits to be detained there until not later than the commencement of the next session of such court occurring on the next business day. Such warrant may also be delegated. Where a sentence provides the defendant is imprisoned, the court shall advise the defendant that if he is unable to pay the fine, he has a right at any time to apply to the court to be resentenced. Once a sentence of imprisonment has commenced, the sentence may only be changed by nobody. Which are true regarding sentence of probation. 1. A sentence of probation is a person under the sentence is in the legal custody of the court. True. If at any time during the period of probation, the court has reasonable cause to believe that the defendant has violated a condition of her sentence, the court may declare defendant delinquent and file a written declaration of delinquency. 3. If at any time during period of probation, the probation department has reasonable cause to believe the defendant has violated a condition of their sentence, the department may apply for a declaration of delinquency. If at any time during the period of probation, the court has reasonable cause to believe defendant has violated a condition of her sentence, the court may issue a search order or a warrant. When the court receives a request for a declaration of delinquency by a probation officer, it shall make a decision on such request within 72 hours of its receipt. 5. A short form probation report may be used when defendant is convicted of a misdemeanor. This is 390.30 sub 3, the report and victim impact statement. A. The report of the pre-sentence investigation must contain an analysis as the agency deems relevant. The report must include information as the court directs and the material required by B, which shall be considered a part of the report. And B is the victim impact statement, which shall include an analysis of the victim's version of the offense, the extent of injury or economic loss, and the out-of-pocket loss to the victim, and the views of the victim relating to disposition and the amount of restitution or reparation sought after they're informed of the right to seek it, subject to the availability of such information. In the case of a homicide or where victim unable to assist, the information may be acquired from the family. Now, this is basically talking about felony. Okay, this is when the victim is the victim of a felony. So somebody robbed them a lot of money or something, or robbed them. The victim impact statement shall be made available to the victim by the prosecutor. Nothing contained in this section shall be interpreted to require that a victim supply information. So they have to at least try to get information, but they can't force the victim to give it. Now, 4 says abbreviated investigation and short form report. In lieu of the procedure described above, where conviction is a misdemeanor, the scope may be abbreviated and a short form report made. They shall be in accordance with general rules regulating methods and procedures in the administration of probation as adopted by the Commissioner of DCJS pursuant to Article 12 Executive Law. No such rule shall be construed to relieve the agency of conducting and reporting on A, the extent of the injury or economic loss and the actual out-of-pocket loss to the victim, including the amount of restitution or reparation sought, or B, any matter the court directs to be included. 5, information to be forwarded to State Office of Probation and Correctional Alternatives. That's SOPACA. Jeez. Investigating under this agency shall have reports. They must transmit them annually to the Office of Victim Services and included in the office's biennial report. So the office does 2 reports pursuant to the executive law, and their information has to be sent to like probation or whoever's the investigating agency annually. Intern probation supervision. After consultation with the prosecutor and consent of defendant, the court, in any case where the defendant is eligible for probation, may adjourn sentencing for 1 year and may, upon the defendant's consent, extend it for another year where defendant has agreed to and is still participating in a drug program in connection with the court designated as a drug court by the fucking chief administrator. When ordering the person gets interim probation supervision, the court shall impose all the conditions relating to supervision and may impose the conditions relating to conduct and rehabilitation. The defendant must receive a written copy of the conditions at the time they're placed on the supervision. The record of compliance shall be included in the pre-sentence report, an updated pre-sentence report, and the court must consider such a record when pronouncing sentence. If the defendant satisfactorily completes a term of interim probation supervision, they shall receive credit for the time served towards any probation sentence that is subsequently imposed in that case. In its discretion, the supervising probation department may use a bunch of sections, I don't remember what they are. Okay. Defendants or prosecutors present a memorandum. They can both file a memorandum. Defendant may annex written statements by others in support of facts. Memorandum of the prosecutor shall be served on defense counsel at least 10 days prior to sentence. 3. The act of seeking health care for someone who's experienced a drug or alcohol overdose or other life-threatening medical emergency shall be considered by the court when presented as a mitigating factor in any controlled substance prosecution, alcohol-related offense, or drug paraphernalia, or marijuana, because, you know, lots of people die from smoking weed. 390.50. Any pre-sentence investigation where there's medical, psychiatric, or social agency report or submitted to the court is confidential and may not be disclosed. except on authorization of the court or permitted by statute. For the purpose of section, any report, memorandum, or other information forwarded to a state probation department within the state from a probation agency outside the state is governed by the same rules of confidentiality. Not less than one court day. They have to get the stuff, the probation report. The court makes, except from disclosure of part which are not relevant, or a diagnostic opinion which might seriously disrupt a program of rehabilitation or other sources of information that have been attained on a confidentiality promise. If something is not disclosed, the court shall state for the record the reasons why it's been disclosed and what's been disclosed. The action of accepting the information shall be subject to appellate review. The pre-sentence report shall be made available to the court by the probation department, and then one court day in advance. They have to give it to them, the prosecutor and the defense counsel. Upon written request, court shall make a copy of the report, other than the redacted portions, available to defendant for use before a parole board or release consideration. In his or her written request, the defendant shall affirm that he or she anticipates an appearance before the parole board or intends to file an administrative appeal of a parole board determination. The court shall respond to defendant's written request within 20 days from receipt of the request. The DA has to give 21 days notice of the victim's family or victim when there's a felony sentence, including the obligation to inform the court of its intention at least 10 days in advance prior to sentencing to make a statement. If the victim did not get timely notice, the court may proceed with sentencing if it determines that the victim and defendant have had reasonable notice, or may adjourn sentencing for not more than 7 days in order to afford reasonable notice. Now, I remember that being just defendant, but it says if the victim did not get timely notice, the court may proceed with sentencing if it determines that they got reasonable notice, if the defendant and the victim got reasonable notice, or may adjourn sentencing for not more than 7 days. Failure to give notice does not affect the sentence. Okay, so it says public agencies within the state. Probation department must make the report available to any medical, psychiatric, or social agency submitted to it in connection with its report or supervision of defendant, to any court or to the probation department of any court within New York that has jurisdiction over the person for the purpose of pronouncing or reviewing sentence, and to any state agency to which the defendant is committed. In any such case, the court or agency receiving the material must have it retained under the same confidentiality provisions. Except that an agency with jurisdiction, as that term is defined in 10.03 Mental Hygiene Law, shall make such information available to 1. Commissioner of Mental Health, 2. Attorney General, 3. Case Review Panel, 4. Psychiatric examiners, when they require the material and exercise their statutory functions, powers, and duties under Article 10 Mental Hygiene Law. They can also make it available to an outside state's probation department, parole, or public institution agency. The division. Nothing contained in this section may be construed to prevent the voluntary submission by probation department of data in its files to the division. 6. Professional licensing agencies. Probation department shall provide a copy of persons who are known to be licensed if they are a physician, PA, or specialist assistant, and to the state education department with respect to all such licenses. Such reports shall be accumulated and forwarded every 3 months, and shall be in writing, and may be submitted hard copy or electronically, and shall contain the following information: A. The name of the licensee and the profession. B. Date of conviction and nature. And C. Index or other identifying file number. In any such case, the state department receiving the material must retain it under the same conditions of confidentiality. Okay, let's resume with the test. Question 1, Test 7, 420.10. The maximum amount of time a defendant may be imprisoned if the defendant fails to pay the fine, restitution, or reparation, 15 days for a violation, 1/3 the authorized maximum term of imprisonment for a misdemeanor, 1 year for a felony. Question 2. CPL 430.10. Once service of the sentence imprisonment has commenced, the sentence may not be changed by anyone, including apparently the governor. Question 3. Which sentences are true regarding probation? 1. A person under a sentence of probation is in the legal custody of the court. True. 2. If at any time during the period of probation the court has reasonable cause to believe the defendant has violated a condition of their sentence, the court may declare the defendant delinquent and file a written declaration of delinquency. True. When this happens, the period of probation tolls. True. If at any time during the period of probation the court has reasonable cause to believe defendant violated a condition of their sentence, the court may issue a search order or a warrant. True. 4. When the court receives a request for a declaration of delinquency by a probation officer, it shall make a decision on such request within 72 hours of its receipt. The court shall make a decision on such request within 72 hours of its receipt. True. 5. A short form probation report may be used when defendant is convicted of a misdemeanor. True. 4. 380.40. Sentence may be pronounced against a corporation in the absence of counsel if counsel fails to appear on the date of sentencing after reasonable notice thereof. Question 5. 380.55. Where a defendant has been assigned to represent